Thank you. The next item of business is a debate on motion 19221 in the name of Angela Constance on the Criminal Justice Modernisation and Abusive Domestic Behaviour Reviews Scotland Bill at Stage 3. I would invite those members who would wish to speak in the debate to please press the request to speak buttons, and I call on Cabinet Secretary Angela Constance to speak to and to move the motion. Up to 7 minutes, please.
Presiding Officer, I would like to start by thanking all those who have engaged in the Criminal Justice Modernisation and Abusive Domestic Behaviours Review Scotland Bill throughout its passage. I'm very appreciative of the work of Parliament and the committees that considered the bill, particularly the members of the Criminal Justice Committee, past and present, and their clerks. And I'd like to thank my bill team and private office, as always, for their support. Presiding Officer, this bill is in two distinct parts. Part 1 of the bill provides resilience to the criminal justice sector by embedding efficiency and modernisation in procedures, making sure our criminal justice system can meet current and future demands upon it. Therefore, I would also like to put on record my appreciation for the efforts day and daily of those working in the criminal justice system, as well as those who work more widely to support people affected by what can sometimes be deeply devastating and traumatising experiences. The second part of the bill will establish a new domestic homicide and suicide review model, and my gratitude goes to all those involved in getting us to this point today, and in particular to the members of the Domestic Homicide and Suicide Review Task Force and other stakeholders. Their contribution, commitment and constructive challenge in ensuring this model will achieve its overall aims has been invaluable. Presiding Officer, this bill seeks to make permanent some of the temporary provisions first put in place through the emergency legislation passed in response to the coronavirus pandemic and continued by this Parliament through subsequent legislation. And although these measures were introduced in the context of an emergency, they achieved much-needed modernisation and laid essential groundwork for a number of the provisions in the bill before Parliament today. Most provisions in Part 1 of the bill have been in place for over 5 years now and have become a vital part of the justice system. Where members of this Parliament have made recommendations for improvements, such as on virtual attendance and national jurisdiction, I am pleased to have worked with them to improve the bill. Part 1 of the bill also introduces new provisions that aim to support greater modernisation and enhance effectiveness in the justice processes. They will support the further rollout of the groundbreaking digital evidence sharing capability and Police Scotland's use of body-worn video, both essential technologies that are transforming the operation and delivery of justice services. Presiding Officer, Part 2 of the bill establishes a gold standard for domestic homicide and suicide reviews. Whilst we would all wish that this wasn't necessary, the purpose of these reviews is to learn lessons following domestic abuse-related deaths, improve services and better protect victims. Our work to develop a national domestic homicide and suicide review model began in 2022 and has been guided since then by a multi-agency and multidisciplinary task force. This bill is an important part of how this gold standard will be achieved, but legislation alone will not secure this. The statutory guidance, continued hard work and dedication of stakeholders is also needed, and it is Part 2 of the bill in particular which has highlighted the exemplar partnership working of stakeholders and demonstrated what can be achieved by working constructively together and what more can be done. Presiding Officer, I am therefore pleased to tell Parliament that I want to go further in this work, and that is why I have commissioned Healthcare Improvement Scotland to work with stakeholders to develop national standards for domestic homicide and suicide reviews to support the review model to meet and exceed that gold standard that victims and their bereaved families deserve. Scoping workshops with key stakeholders will be held next month, and standards development group will shortly be established. The development group will be co-chaired by Professor John Devaney of the University of Edinburgh and Dr Edward Doyle, Deputy Medical Director of NHS Lothian. It will include strategic and operational expertise from across health, social care, justice and third sector. Importantly, this work will be underpinned by the experiences of families and people with lived experience. Presiding Officer, any death in connection with domestic abuse is one too many, and whilst we know there is more that can be done and that needs to be done, the establishment of a domestic homicide and suicide review model backed by national standards will help ensure that Scotland implements best practice in establishing a review system with the aim of learning lessons, improving services and better protecting victims. Presiding Officer, let me conclude by reiterating my thanks to the committees that considered the bill and the wide range of individuals and organisations who brought significant operational, legal and academic expertise to its development and progress, and those who have shared their lived experience of domestic abuse and those bereaved by it. I move that Parliament agrees that the Criminal Justice Modernisation and Abusive Domestic Behaviour Reviews Scotland Bill be passed.
Thank you, Cabinet Secretary. I now call on Liam Kerr to open on behalf of the Scottish Conservatives. Up to 6 minutes, please.
Thank you, Presiding Officer. The Scottish Conservatives will vote for the Criminal Justice Modernisation and Abusive Domestic Behaviour Review Scotland Bill at decision time today. Before I deal with the specifics, I wish to reiterate some remarks I made earlier in the process. Firstly, there are two parts to this bill which cover quite distinct aspects. Part one is focused on introducing on a permanent basis some of the criminal justice measures in the coronavirus legislation, whilst Part 2 introduces a review mechanism for deaths in the context of abusive domestic behaviours. I remain unpersuaded of the merits of locking two very distinct mechanisms together in this way. My fear, as I set out at stage one, is that this can lead to different parts receiving different levels of scrutiny and interest. And although I don't think this is the case here, I think there's a risk, if we're doing this sort of thing with bills, that those who might support one part very strongly, but perhaps oppose the other, are left in quite an invidious position when we come to this stage. I also remain of the view that the timescale for consideration of this bill is not ideal. As I flagged at stage one, the Justice Committee and this Parliament have been wrestling with both the Victims Bill a fortnight ago, then the Housing Bill last week. The Land Reform Bill is also imminent, and this is exactly what I warned about by reference to an op-ed by my colleague Edward Mountain at stage one. There are those who might fear that this bill has been somewhat rushed or been given less attention than it merits as a result, with the risk that opportunities are missed, which is a theme I wish to return to when I deal with Part 2 specifically. So looking specifically at each part, Part 1 contains measures that aim, according to the policy memorandum, to improve future resilience, effectiveness and efficiency of the criminal justice sector through modernisation, in particular through greater use of digital processes. It does so principally, but not entirely, by making permanent some of the coronavirus temporary provisions. Those measures include electronic signing and sending of documents in criminal cases, enabling virtual attendance at criminal courts, removing geographical limitations on criminal courts dealing with initial stages, and also permitting digital pictures to be used, raising the limit on fiscal fines and dealing with time limits on solemn cases. The Scottish Conservatives are comfortable entirely that Part 1 achieves the aims of the policy memorandum. Part 2 establishes a framework for a national system of domestic homicide and suicide reviews. The idea is to identify what lessons can be learned and potentially applied following a death where domestic abuse is known or suspected in order to help prevent future abuse and deaths. Now again, this has been welcomed throughout the bill's passage, but I think it's fair to say it's required more involvement around things like definitions, overlaps and especially costs, which again I wish to return to in short order. But before I do, I want to bring my concern back about the timescales for this bill. You see, we have received a very helpful Stage 3 briefing from Scottish Women's Aid, who have campaigned for the matters in Part 2 for nearly 10 years now. Crucially, they also seek to, quote, draw your attention to concerning omissions from the bill, which they then proceed to do. Presiding Officer, I worry that with so much focus, understandably, being on other bills, we as a Parliament may have inadvertently missed some of the opportunities that Scottish Women's Aid suggests. And I'm pleased to know that the Cabinet Secretary takes Scottish Women's Aid's suggestions very seriously indeed. Furthermore, I mentioned the costs of these measures earlier. At stage 1, I raised that Police Scotland flagged that the financial memorandum is silent on the anticipated financial impact on the police budget. And I don't see any significant additional information or reaction since. Now, it was contended that a lot of the finance will only be known upon implementation, but given the SPF's, the Scottish Police Federation's warning to the committee, which has been reported widely just today, that without extra funding, policing in Scotland could be, quote, unsustainable, this lack of financial certainty would seem particularly concerning, particularly if this legislation is loading yet more responsibility onto the police. And indeed, COSLA, before stage 1, noted that, quote, the financial memorandum does not reflect the costs and capacity needs of local authorities and their strategic community planning partners. Now, it was said at the time that both the stage 1 financial memorandum and the revised memorandum that was produced after stage 2 provisions are not expected to give rise to any additional costs on local authorities. But the Cabinet Secretary will well recall the Finance Committee's concerns in recent years about the quality, or indeed otherwise, of financial memoranda in this Parliament. And I think it would be fair to say that whilst the memoranda are fairly clear about publication and the like, they are less clear about the full cost of staffing, training, maintenance of new IT and digital systems, the costs of bringing courtrooms up to standard for virtual hearings, and perhaps any additional legal aid or court representation costs if there are increased numbers of hearings, reviews, or more people require assistance because of the shifting of some processes to court or review. But all that being said, Presiding Officer, we will be asked at decision time whether the Scottish Conservatives will vote for this bill, and I confirm that we will do so. Thank you.
Thank you, Mr Kerr. I now call on Polly McNeill to open on behalf of Scottish Labour. Up to 7 minutes, please.
As you've heard, the bill covers two distinct issues: criminal justice modernisation and domestic homicide and suicide. Reviews like Liam Kerr, Scottish Labour are not in favour of putting two distinct issues together because we might have disagreements, and in some ways we've been here before. However, we will be supporting the bill tonight because we do believe in modernisation and we do think that part 2 of the bill is really required and is an excellent piece of legislation. Most of the focus has been on the modernisation aspects of the bill. As I've tried to demonstrate with my amendments, there's quite a lot for non-practitioners and legislators to understand about the status quo in courts versus the new arrangements. And for us, it's the principle that we are trying to pursue here is to try and confirm what's already in use and to ensure that there's no loss of existing rights and that there's no detriment to the interests of justice in the court system. So I think we were right to test those issues. A lot of the detail in the bill is by regulation, not in the face of the bill, so there is still a lot, I think, to put on trust. As was put to me by a lawyer, if the system works the way it's supposed to work, then there's no reason why it won't go well. Sometimes that doesn't always happen. I have no doubt everyone's best intentions, but we need to make sure there is not institutional creep, which I've tried to tease out in the areas, and that's why I did actually really wholeheartedly welcome, I think, small amendments, but really important amendments that the government brought forward today. I cited examples at stage 1 in the committee about previous times where we agreed the time limits for High Court trials being 180 days. And look where we are now. The delays in the High Court system were well before COVID because the law was not adhered to in relation to time limits. And that's my example. Sometimes things can creep in that we didn't really intend. So that's why I think we've got to be vigilant. The bill makes permanent the temporary provisions relating to virtual attendance to increase its use. Virtual attendance is a very important tool supported by victims' organisations and the legal sector. Without it, we know some victims simply could not give their evidence, and it allows cases to proceed in circumstances that previously would have been prevented from doing so. Interestingly, the police witnesses to the committee at stage 1 demonstrate that there's more work to be done in making sure that it is an efficient aspect of reducing police time in court, as they weren't as enthusiastic about that as I thought they might be. I think that's an important issue to note. And it's extremely important from the point of view of victims to note that virtual attendance should have the same value as a courtroom, not just because of creating the solemnity of the quality between the courtroom and virtual attendance, but it's really important to always ensure that the quality of evidence that victims give is taken as seriously as giving evidence physically in court, and for that reason there should be ongoing research to ensure that. The bill sets out the Lord Justice General has the power to issue determinations to change the default position to virtual attendance for particular categories of cases, and my amendment supported by the Government stated that the Lord Justice General must provide reasons in making any determination, and I also think that's an important step, because as we examine the reasons why virtual attendance is granted by the Lord President, then it's important to see what the rationale is. I'm glad the Government had accepted that. And the committee noted that it should be a case-by-case basis and not class of trials that virtual attendance has to be used for. So that's quite clear. I'm also broadly satisfied with the Government's amendment on national jurisdiction that my colleague Katie Clark brought out in her amendments, and I agree with the Law Society here that local justice should still be preferred where possible, and that changes should only be made to make the system smoother. On the issue of digital productions, my intention here is I didn't want parties to lose their existing rights over the physical images, and sometimes it can be important for the jury to see the physical item in court. But I'm satisfied that what we've heard from the Cabinet Secretary today and at stage 2 is that they will not be denied that, and there is a process for doing that. In conclusion, Presiding Officer, I think it's important to welcome the national standards of review cases involving domestic abuse and homicide is a really important aspect of this legislation. If we are to prevent and stop the alarming trends of violence against women and girls, then we must do everything we can to understand why it happened in the first place. Notwithstanding what Liam Kerr had to say about this, there could have been more improvements. I think if we had more time to focus specifically on that aspect of it, I believe and welcome that this legislation will enhance our knowledge and our processes in the fight against women and girls. And that, Presiding Officer. Thank you.
Thank you, Ms McNeill. I now call on Maggie Chapman to open on behalf of the Scottish Greens. Up to 4 minutes, please.
Thank you, Presiding Officer. Before I begin, I remind colleagues of my register of interests. I worked for a rape crisis centre when elected in 2021. Today we reach the final stage of the Criminal Justice Modernisation and Abusive Domestic Behaviour Review Scotland Bill, one that is both technical but also deeply human. At its heart lies a question: how can we make our justice system not only faster or more efficient, but also more compassionate, equitable and restorative, a more humane system that upholds fairness, care and compassion for everyone it touches? This bill offers us a step in that direction. It speaks to a modern Scotland, one that recognises that justice must evolve to meet people where they are, in the 21st century and in the realities of their lives. I'm pleased that this bill, through its reforms to criminal procedure and the creation of domestic homicide and suicide reviews, represents progress toward a system that listens, learns and acts with integrity. Part 1 of this bill, as we've heard, brings forward reforms that make permanent many of the emergency measures first introduced during the pandemic: digital submissions, virtual attendance and electronic documentation. These may sound procedural, but as Victim Support Scotland has reminded us, they have made a real difference for victims and witnesses, reducing delays, cutting travel time and cost, and improving the smooth running of proceedings. The ability to give evidence virtually can spare victims the trauma of being in the same courtroom as the accused. It can make participation possible for those who would otherwise struggle to attend in person. We must ensure that these reforms are delivered in a way that enhances accessibility and choice. Modernisation must never become a barrier to justice. It must open doors, not close them. That's why I welcome the Government's commitment to reviewing the impact of virtual attendance and to working with organisations like Victim Support Scotland and Scottish Women's Aid to ensure trauma-informed practice is embedded in every part of the justice process. And I welcome Liam Kerr's work in this area as well. Victim Support Scotland has also made clear that victims and witnesses now expect this flexibility and that taking it away would be a backward step. They have also reminded us that victims must be kept informed of developments, including any changes to charges or indictments. Communication is not a courtesy. It is a right in this case. Part 2 of this bill, the creation of a statutory model for domestic homicide and suicide reviews, is long overdue. Scottish Women's Aid and others have campaigned for this for nearly a decade. They have called for a framework that allows us to learn, with honesty and care, from the most devastating cases of domestic abuse and coercive control. These reviews will not undo tragedy, but they will help prevent repetition. They will shine a light on where systems fail, in housing, in policing, in health, and in the coordination between these and other services. Both Scottish Women's Aid and Victim Support Scotland have stressed that these reviews must be independent, properly resourced and inclusive. The voluntary and specialist sectors, those closest to survivors and families, must have a guaranteed seat at the table. And I welcome the Scottish Government's assurances that this will be reflected in statutory guidance. For me, Presiding Officer, justice must be feminist, restorative and rooted in compassion. It must not only punish harm, but work to prevent it, to build systems that protect, heal and repair. This bill does not do everything, as we've already heard this afternoon, but it does move us forward in the right direction. It offers a foundation on which to build a justice system that is responsive to people's lives and experiences. So let us pass this bill this evening, not as the end of a process, but as the beginning of lasting change. Thank you.
Thank you, Ms Chapman. And I now call Liam MacArthur to open on behalf of the Scottish Liberal Democrats. Up to 4 minutes, please.
Thank you, Presiding Officer. Can I start by thanking and congratulating the Justice Committee, the Cabinet Secretary and indeed stakeholders for what has quite clearly been a collaborative and constructive process. I think I share some of the concerns I expressed this at stage 1, shared the concerns expressed earlier in this debate by Liam Kerr and by Pauline McNeill about the fact that we are dealing with two very distinct issues here, and ideally they would form part of standalone primary legislation. However, I think it's fair to acknowledge that were they to be in separate legislation, chances are one or either would not have made it through during this session of Parliament. And I think some of the concerns that were being expressed at stage 1 had been addressed through the process. As others have observed, Part 1 deals with many of the modernisation aspects that were introduced during the pandemic. I think it's right that we take time during peacetime to reflect on how these might be made more permanent, but surrounded by the appropriate guidance and structures that stakeholders would expect. But certainly the modernisation of our criminal justice system is long overdue, and making best use of technology and digital advancements is entirely sensible. For example, the electronic signing of legal documents as well as digital copy mechanisms are very positive outcomes, if, again, long overdue, and have been welcomed by stakeholders from Law Society to Victim Support Scotland. Virtual attendance, again, as we know, is a measure that has been in place for many years across the Scottish criminal justice system, and there are benefits from it. But as we look to broaden it out, again, I think time needs to be taken to make sure that we put in place the proper safeguards and guidance around that. Can I also acknowledge the efforts, particularly of Liam Kerr and Pauline McNeill, in taking forward amendments to stage 2 and again at stage 3, endeavouring to ensure these provisions are indeed workable and as efficient as they can be. The Law Society, having previously raised concerns about the permanent inclusion of virtual attendance, do now appear to be more reassured, and I think that's testament to the good work that has been done since stage 1. Ultimately, remote attendance can be beneficial in giving victims agency during often traumatic processes, and making the option more widely available has been endorsed by Victim Support Scotland. I would, though, make a plea that this is something that cannot be done on the cheap, and resources will be necessary to ensure the infrastructure is there to support it. Moving briefly to part 2, introducing a system for reviewing deaths which relate to abusive behaviour in relationships, with the aim of identifying where opportunities for intervention were missed and improving the better understanding of the profile of abusive domestic behaviours and the associated risks. I think, again, while at stage 1 I expressed some concerns about the complexity of the review landscape, I think progress has been made over the course of stage 2 and stage 3 to begin to address some of those concerns, notwithstanding some of the concerns I have more broadly about the need for reform of our FAI system. I was assured by the Cabinet Secretary's indication that stage 2 that statutory guidance will set out in particular the safeguards that have been looked at in relation to children and young people, and that steps will be taken to ensure that families are not subject to additional lengthy review processes as a result of this. So, as I say, it's not ideal that we're seeking to deal with two very distinct issues in the context of a single bill, but it does appear to me that the process that's been embarked upon through stages 2 and 3 have, as far as possible, addressed those concerns, and Scottish Liberal Democrats will be pleased to support the bill at decision time this evening. Thank you.
Thank you, Mr MacArthur. We will now move to the open debate, and I call Audrey Nicholl. Up to 4 minutes, please.
Thank you, Presiding Officer. And can I also begin by thanking everyone who supported scrutiny of the bill through its passage to stage 3 this afternoon. So, as we've heard, the Criminal Justice Modernisation and Abusive Domestic Behaviour Reviews Scotland Bill seeks to do two things. Firstly, to provide a basis upon which our justice system can continue to modernise, specifically through embracing digital technology. And secondly, to establish a review process that supports learning in the aftermath of a domestic homicide or suicide. So, I just want to make a couple of points this afternoon. So, firstly, on stage part 1. Now, justice systems do value tradition, and it's certainly no different here in Scotland, where deeply rooted customs and formal rituals are highly regarded. Now, the COVID-19 pandemic obviously posed a monumental challenge for the justice system, but in doing so created an opportunity to modernise the justice sector through greater use of digital technology. And the bill seeks to make certain processes permanent, one of which is virtual attendance at court, which has already been examined in detail already this afternoon. Now, at stage 1, as we've heard, there was strong support from victims' organisations, citing trauma-informed practice, giving victims agency, as we've heard. However, this provision did understandably raise a number of questions about the scope, reliability of technology, appearance from custody and security, that is, ensuring witnesses are not susceptible to any undue influence. Now, this latter point was discussed earlier this afternoon, and I think a key point to remember that the Cabinet Secretary referenced is the default arrangement whereby attendance should be in person. And I do agree Pauline McNeill's Amendment 58, proposing a requirement for closer supervision of anyone attending court virtually, while well intended, would have it had monumental resource implications and would have been completely unworkable. Now, I am pleased that since the stage 1 debate, the Scottish Government have engaged with stakeholders, including the Lord Justice General, on virtual attendance, and there is consensus that the current provisions have been in place for some time, practitioners are familiar with them, and that they work well as currently framed. I also very much welcome the Government amendment on the addition of charges to an indictment, and I note the conditions outlined by the Cabinet Secretary. I really welcome that amendment. So, turning to part 2, Scotland does not currently have a statutory system to review deaths linked to domestic abuse, meaning the opportunity to learn lessons is lost. Now, during Stage 1 scrutiny, the question of the scope of the review process raised questions insofar as it is broader than the current definition of domestic abuse as it's outlined in the Domestic Abuse Act of 2018. Now, the Criminal Justice Committee heard conflicting views on whether the definition in the bill was too wide in scope and should only apply to incidents that would fall within the definition of the 2018 Act. Now, strong arguments were made by Emma Forbes of Crown Office and Dr Marcia Scott of Scottish Women's Aid on this point. On the other hand, it was recognised that many of those experiencing domestic abuse do not report their abusers to the police. This is often an action of last resort, and so a broader definition would create wider opportunities for learning through the review process and to prevent future deaths. And I do agree with the view that the impact of domestic abuse reaches beyond the relationships set out in the 2018 Act, and that the bill allows wider opportunities for learning and ultimately the prevention of future deaths. So to conclude, Presiding Officer, I very much welcome the provisions in the bill. They reflect Scotland's justice system is determined to modernise and move with the times. So I ask members to support the bill this evening. Thank you.
Thank you, Ms Nicholl. And we now move to closing speeches. And I call on Maggie Chapman to close on behalf of the Scottish Greens. Up to 4 minutes, please.
Thank you, Presiding Officer. As we close this debate, I want to thank everyone who has shaped this bill. Survivors, campaigners, practitioners and the organisations whose expertise has been essential, specifically Scottish Women's Aid, Victim Support Scotland and the many, many others. Of course, I thank to the Criminal Justice Committee members and clerks for their meticulous scrutiny of this legislation, the legislation team for all their work, and I am very grateful to the Cabinet Secretary and her team for the various discussions we've had about this bill over past months. This bill is rooted in learning and listening. It reflects what can happen when we listen, when we really listen to the experiences of victims and survivors. Victim Support Scotland has been clear. These reforms must make justice smoother, safer and more humane. The flexibility of virtual attendance, the use of digital evidence and the modernisation of documentation are not simply technical improvements. They are changes that reduce trauma and delay. But, as Scottish Women's Aid has warned, technology alone is not enough. Modernisation must be guided by trauma-informed feminist principles. Survivors of abuse must have choice and control over how they participate in proceedings. The Greens support these measures because they show that efficiency and empathy can go hand in hand, that a justice system can be both effective and compassionate. The second part of this bill, the establishment of domestic homicide and suicide reviews, reminds us that justice is not only about courts and trials, but about learning from failure. Both Scottish Women's Aid and Victim Support Scotland have championed this reform because they know what is at stake: real lives, real families, and real grief. Victim Support Scotland's work with families bereaved by murder and culpable homicide give them a unique perspective. They have rightly insisted that families must have a voice and must have choice and control in these reviews, including the right to request reconsideration when new information emerges. And Scottish Women's Aid has made clear that these reviews will only succeed if they are independent and transparent, with equal representation from the third sector. Their expertise must be embedded, not merely consulted. But, Presiding Officer, passing this bill is only the beginning. We must now ensure that reviews lead to change, that recommendations are implemented, tracked and made public, that families are supported through every step, and that survivors see a system that learns rather than repeats its mistakes. Because justice can never be static. It must evolve with empathy, grounded in the belief that every life lost to abuse is one life too many. This bill, alongside the Victims, Witnesses and Justice Reform Bill, passed just a couple of weeks ago, can help reshape Scotland's justice system to make it more compassionate, more transparent and more just. It will take vigilance, courage and collaboration to make that promise real, because we know we still have work to do despite the passage of these two bills. But today, Presiding Officer, with this bill, we do take an important step, and the Scottish Greens will proudly vote for it at decision time. Thank you.
Thank you, Ms Chapman. I now call on Katie Clark to close on behalf of Scottish Labour. Up to 6 minutes, please.
Thank you, Presiding Officer, and I'm pleased to close today's debate for Scottish Labour. In relation to Part 1, many of the changes contained in this bill were introduced during the pandemic, and the Scottish Government now seeks to make them permanent. And whilst we are generally supportive of that, we do have some concerns about how far some of the provisions of the bill could extend. We were particularly concerned about whether too many decisions would be discretionary at the hands of the Courts and Tribunal Service, and whether the service is properly resourced to deliver the changes within the bill. Although the Scottish Government have given assurances that there will be no overreach, we believe a monitoring will be necessary to ensure that these provisions do not hinder justice in any way. It's clear that an increased use of digital documents and evidence is vital to modernise the court system. However, there is also a need to ensure that physical evidence can continue to be available in a criminal case if requested, and I think we've put forward those arguments during the debate today and prior in this process. Greater use of digital documents and evidence also raises questions about digital inclusion, which the Scottish Government will have to address. Audit Scotland has previously highlighted that 15% of adults lack foundational digital skills, such as turning on a digital device. And the Scottish Council for Voluntary Organisations has also called on the Scottish Government to publish a digital inclusion action plan. Members have also spoken about the bill's provisions relating to virtual attendance in court proceedings, which were temporary provisions introduced during the pandemic. We believe that making them permanent will both increase their use, but also could help reduce the backlog that still exists in the courts. Many victims' groups and the legal sector have welcomed making virtual attendance a permanent feature of our court systems. However, we would urge the Scottish Government to do more to ensure that virtual attendance is always safe and free from interference, and we do accept that the Courts and Tribunal Service will see that as something that is inherent in the system, whether it's absolutely and utterly watertight on the face of this bill. And also that there is work done to ensure locations offer both a strong video and Wi-Fi connection and good picture quality, as we know that has been in problems in the courts over the last 5 years, and we've heard evidence in relation to that. The concerns of Scottish Women Aid and other organisations relating to virtual attendance provisions in the bill must also be addressed by the Scottish Government. Scottish Women's Aid have argued that the provisions do not go far enough in protecting women, children and young people experiencing domestic abuse. And as I think has already been said in this debate, that is not something that the committee looked at in detail during our scrutiny of this process. And I think even at this late stage, that's something that we need to give thought to, and I'm sure that the Scottish Government will be thinking about as we move forward. So I welcome that the Cabinet Secretary has indicated clearly that she will engage with Scottish Women's Aid and indeed other organisations on the issues that they are raising. As well as increasing the use of virtual attendance, the bill seeks to allow cases in which a person appears from police custody to take place in any sheriff court in Scotland. We recognise that this could lead to savings in court costs, particularly when you look at the costs of transferring prisoners around the country. But many organisations like the Law Society of Scotland have rightly raised the importance of local justice, and these must be issues that are also given adequate consideration. We welcome the creation of a framework to review domestic homicides and suicides in Part 2 of this bill, and agree with the comments that have been made that perhaps this hasn't had the scrutiny that maybe it should have, as we do believe this deals with a gap in existing legislation and frameworks. And we should remember that similar provisions already exist in England and Wales, and that England and Wales do deal with these things in very different ways. So we recognise the vital work that victim support groups have played in developing this framework, but also believe that we need to look closely at how these reviews have worked in other jurisdictions within the UK. We would urge the Cabinet Secretary to address the issues relating to membership of the proposed Review Oversight Committee, which has been raised by Scottish Women's Aid, specifically ensuring proper representation of victim support groups, including those dealing on the front line with violence against women and girls. We are supporting this bill today. We very much hope that the provisions of this bill will allow a modernisation in the courts that improves the experience of those using the courts, of victims and witnesses, but also helps to address the considerable backlogs that still exist within the courts. However, we also recognise that there are far wider issues surrounding resourcing of our courts and the state of legal aid, so we remain concerned that although some of these provisions are very welcome, a great deal more work needs to be done to address the significant backlogs in our court system.
Thank you, Ms Clark. And I now call on Sharon Dowie to close on behalf of the Scottish Conservatives. Up to 5 minutes, please.
Thank you, Presiding Officer. Scotland's justice system is in a state of crisis, and the Scottish Conservatives welcome anything that improves things for those working within it, and of course victims and witnesses too. As such, this bill has our support, and the priority now should be ensuring the changes agreed today will genuinely make life better for those who matter most. While we will vote for the bill, we still have some concerns around implementation and financing, and remain disappointed that some of our suggestions were rejected. Presiding Officer, like many of our institutions, the court system is in desperate need of modernisation, and I am glad to see some sensible provisions in this legislation. As the Cabinet Secretary said, some of these were introduced on an emergency basis through COVID, through necessity rather than design. And while it is right some pandemic-era measures are consigned to history, it is absolutely correct that ones that work well are retained. The court system is under huge duress, with backlogs showing little sign of clearing and fears among senior lawyers that things will get even worse. It's also a system which can cause unnecessary distress and inconvenience to victims and witnesses. Pauline McNeill highlighted that virtual attendance is a positive change, although it is vital the correct technology is in place to make sure such appearances are smooth, free from technical glitches and in good enough quality that it doesn't matter that the person speaking is not in the room, and this was also emphasised by Liam MacArthur. Similarly, the change to photographed evidence must also come with assurances. There is an obvious risk of tampering when real physical things are replaced with photographs, a threat which is becoming greater with advancements in AI. This system must be absolutely bulletproof. Presiding Officer, another element of this bill which requires caution and monitoring is the permanent increase in the fiscal fine limit to £500. On the face of it, this makes sense and represents a strengthening of the system of punishment for offenders whose crime fits this punishment. But we already know criminals are let off with fines when they really ought to be receiving something more serious. That weakens deterrence, emboldening criminals to offend again, safe in the knowledge the gains from their crime will probably outweigh the fine handed down by court. This is particularly true of shoplifting, a scourge which has run out of control across Scotland. Indeed, as the Scottish Solicitors Bar Association highlighted in evidence, shoplifting is already effectively decriminalised, given how readily courts deal with it by way of fines. What must be made crystal clear is that a raising of the threshold does not mean an expansion of how they are used. This increase should absolutely not be seen as a replacement for stiffer punishments. It's disappointing that my amendment, which would have compelled ministers to produce a progress report within a year of this change, was rejected. That will make it harder to know if this new measure is being used as it was intended. And like all legislation, we need to ensure it is matched by resources. We cannot place additional strain on public services without giving them the right tools. That is especially true of the police, who are already under immense strain and upon whom many of these changes will fall. Both Police Scotland and COSLA have expressed concern about funding when it comes to the domestic homicide and suicide reviews. Yet the finances behind this are vague in the bill, and we need to make sure these reviews will work effectively in practice. And Audrey Nicholl highlighted the benefits of this happening. I'm also disappointed my amendment to work with family members when producing these reviews was rejected. We know from experience that when the legal and justice system deals with tragic cases such as these, families often feel marginalised and out the loop. This would have reduced the chances of those mistakes being repeated here, and ministers must now find another way to keep them included. And Maggie Chapman highlighted the importance of communication. Liam Kerr also highlighted the differences between Part 1 and Part 2 and the risks of rushing through legislation, as we may not give it the scrutiny it deserves or indeed miss opportunities to include more improvements. And I do think that's something that we need to look at in the future for any further legislation that comes through. Katie Clark also highlighted concerns in digital inclusion. Presiding officer, for far too long in Scotland, victims have played second fiddle to criminals. Victims have been let down by a justice system which doesn't punish or deter, doesn't keep communities safe and doesn't rehabilitate offenders. Today, there is at least an opportunity to reverse some of that decline. That is why we will vote for this, but this must be the start of a sea change, not a ceiling for victims and witnesses, and not warm words matched by little action. Thank you.
Thank you, Ms Dowie. I now call on Cabinet Secretary Angela Constance to wind up the debate on behalf of the Scottish Government. Up to 6 minutes, please.
Thank you very much, Presiding Officer. Let me again thank everyone for their constructive engagement on this bill and for their remarks this afternoon. In particular, Criminal Justice Opposition spokespeople, members of the Criminal Justice Committee, as well as the convener, Audrey Nicholl. They are indeed a busy committee. They have my sympathy. I, of course, note the views of Liam Kerr when he spoke about this being a two-part bill. There are, of course, pros and cons of that approach. I suppose, like Liam MacArthur, I fall down into the side of pragmatism, and I'm always looking to get things done, particularly given where we are in the parliamentary cycle. And actually, I do feel there's been significant scrutiny, but that's perhaps just because of where I sit. And I think the scrutiny, particularly around Part 1, has been detailed, and we have certainly, if I can say, been in the weeds of court procedure and process. And I am pleased that the bill now has, broad agreement and consensus on its aims, and I am particularly pleased that it looks as if the bill will pass on the final vote this evening, because this bill will deliver the necessary legislative underpinning that will ensure our justice system can continue to meet the demands placed upon it. It does provide a solid foundation to ensure that we learn the lessons following domestic abuse-related deaths, improve services and ultimately better protect victims. And justice agencies and victim support organisations strongly support the temporary measures which the bill will make permanent, and have been very clear that these are essential features of a modern system. And in terms of court backlogs, if I may remind Chamber that significant progress has been made in reducing these. The total number of scheduled trials outstanding has fallen by over 60% since January 2022. And we have reached the milestone of returning to a position where the number of scheduled trials across all criminal business types is now below 20,000, and this is considered a manageable level of workload by the Scottish Courts and Tribunal Service for the justice system. However, I do acknowledge that the increased demand, in particular on the High Court, is an area that we have to give very focused and acute attention on, so the nature of that business is changing, even although the volume has returned to, overall, has returned to pre-pandemic levels. And of course, investments such as the £33 million in the digital evidence sharing capability that's currently been rolled out will very much support the provisions in the bill on digital productions. And again, if I may take exception to the issue that shoplifting has effectively been decriminalised in this country, I was sharing with some colleagues earlier that as I am rightly notified of every death in custody, I can advise Chamber that there was one such death of a person who was in custody for shoplifting ×7. So I really cannot... I will indeed.
Jackie Bailey. Just on that point, I couldn't leave be silent on it, because in my community there are not enough police on Dumbarton High Street, and the number of people shoplifting and getting away with it is acute. It is a real problem, and I would be grateful if the Cabinet Secretary would acknowledge that. Cabinet Secretary.
I can indeed acknowledge that shoplifting is certainly a problem for our communities and our retail sector. That's why our budget for this year has invested £3 million to tackle these issues. And indeed, there are improvements that are being seen as a result of that investment that I can demonstrate if the member is wishing. I was purely making the point and challenging the point that shoplifting has not been decriminalised in this country, and indeed that our budget of £1.64 billion is maintaining police numbers at 16,500, and indeed over the past year or so Police Scotland has recruited more police officers than at any time in its history since 2013. It is important, Presiding Officer, to acknowledge the concerns of members. I have appeared before committee on an annual basis with respect to the temporary measures, now hopefully permanent measures, after decision time. And I do give the assurance to members that I will, in my closing remarks, although I will continue to focus more on part 2, that I will continue to work with Scottish Women's Aid. I'm glad Pauline McNeill welcomes the national standards. And Maggie Chapman is right to say that although part 2 in many ways felt very technocratic, particularly in terms of the amendments, it has a very human purpose. And Liam MacArthur is right to say that families should not endure duplication of reviews. But there is always work to do, and that's why the bill has been future-proofed, so that we can return to the issue of so-called honour killings when that policy work has been completed. Presiding Officer, it was a year ago that I introduced this bill. Its publication was marked by the unveiling of a previously unmarked memorial cairn in Holyrood Park in memory to domestic homicide victim Margaret Hall, who was murdered by her husband in 1720. And as I said when I opened this debate, we all wish that the reviews were not necessary, but to all those who have played their part in making sure that Scotland can learn lessons to better protect victims, I do offer my sincere thanks. And if I can quote Fiona Dray, founder and chief executive of Emily's Test, the introduction of domestic homicide and suicide reviews makes a critical step forward in Scotland. These reviews will help us better understand the warning signs so often missed before a tragedy. They will be crucial in helping to prevent so many avoidable deaths whether by murder or by suicide. So today, Presiding Officer, this Parliament has the opportunity to ensure that a review model becomes law, and I urge everyone to support the Criminal Justice Modernisation and Abusive Domestic Behaviour Reviews Scotland Bill. Thank you.
Thank you. That concludes the debate on Criminal Justice Modernisation and Abusive Domestic Behaviour Reviews Scotland Bill at Stage 3. It's now time to move on to the next item of business, and I'm minded to accept a motion without notice under Rule 11.2.4 of Standing Orders that decision time be brought forward to now, and I invite the Minister for Parliamentary Business to move the motion.
Moved, Presiding Officer.
Thank you, Minister. And the question is that decision time be brought forward to now. Are we all agreed? We are agreed. I am aware that there's one question to be put as a result of today's business. The question is that motion 19221 in the name of Angela Constance on the Criminal Justice Modernisation and Abusive Domestic Behaviour Reviews Scotland Bill at Stage 3 be agreed. I am aware that members have not yet voted this afternoon, and as this is a motion to pass the bill, the question must be decided by division, so there will be a short suspension to allow members to access the digital voting system.